This is Agriculture Today. We are joined now by K-State and Washburn University School of Law professor Roger McEowen for our Ag Law segment this week. So, Roger, thanks for joining us.
Good to be with you, Samantha. My pleasure.
Great to have you, as always. And today you wanted to talk about a case of almost equity theft, I guess we can call it. It's a loss of equity through the government, really, this case that we're talking about?
Yeah, that's right. And what has been teed up for the U.S. Supreme Court is a case out of Minnesota where property taxes on a condominium, for various reasons, did not get paid. And there's a statutory process that every state has by which the state, the county, the city, whatever the governmental entity is, can follow that process. And over a period of time, which includes a redemption period, then the property can be sold to pay the tax lien. That much is clear. That's certainly constitutional. But what happened in the Minnesota case was the homeowner's equity in this condominium above the amount of taxes that had to be paid. Well, after the property was sold, there was a tremendous amount of excess profit that the county made off of this, and they kept the funds. They did not reimburse or remit that back to the homeowner in that instance. So that's the question that's before the Supreme Court. Once the amount of the sale proceeds are applied to the tax bill, isn't the landowner entitled to any excess amount representing the surplus equity that they have in the property? One would think so, but the lower courts, both at the trial court level and on appeal in the Eighth Circuit, said that that was perfectly fine for the state to do. The state has a statute that says they can do that. And so that's before the U.S. Supreme Court right now. Whether that type of law, which 12 states have, is constitutional. It's a big deal.
Absolutely. And of course, this situation we're talking about in Minnesota with this homeowner, of course, more of an urban situation with a condominium. But you're worried about this even applying to instances of farms and ranches?
Yeah, it's exactly the same principle. That just happened to be an urban type set of facts, but the same set of facts could apply in the rural setting. If you've got a farm or a ranch, for example, and there are various circumstances where the property taxes become delinquent, and then the state process gets triggered and the redemption period is extinguished, somebody could end up with a tax certificate and a deed out of this thing, and the tax lien could be paid off, and the county could end up bagging that surplus equity and not remit that back to the farm owner or the ranch land owner in that situation. So the principle is the same. It could easily be applied in a rural setting. And in fact, there are a couple of cases out there where it has applied to a farmer or a rancher.
I guess the difference here, though, of course, that's impactful for this individual in Minnesota. It's sad, of course, there. But it's even more impactful when we think about the amount of equity that, farmers and ranchers have in the land that they own.
Oh, the number one asset for most farmers and ranchers in terms of value in their estate or what they own is clearly, in most instances, the farmland, the ranch land. And over a period of time, that equity builds up. And it can be, in many instances, several $1 million. This is why we worry about the application of the federal estate tax to a farm or a ranch, and particularly if that's going to drop down starting in 2026 to $5 million adjusted for inflation in 2011 dollars. That's a bigger deal than if it's $12.92 million, which it is right now. And indeed, there was a Nebraska case in 2018 where there was a 480-acre farm near North Platte that was worth $1.1 million. And there were $50,000 in delinquent taxes. And what happened was that the landowner was a 94-year-old widow, ended up in a nursing home, and her son had power of attorney. Well, the son delegated his power of attorney, assigned it to a bank for the bank to take care of things. And in the shuffle of all of this, the son assumed that the property taxes were being paid by the bank. The bank didn't know about that because they weren't getting the notices. The owner's in a nursing home, and just by virtue of a mess of circumstances, it slipped through the cracks. It gets $50,000 in delinquent taxes. And before anybody realizes this farm comes up for sale. And it sells for that market value, and the county, well, they lose the farm in that instance for the failure to pay the property taxes. Now, in the wake of that decision, the legislature in Nebraska, the Unicam in Nebraska, changed the requirements for service of notice when you're applying for a tax deed. So hopefully something like this doesn't happen again. And indeed, in Massachusetts, there was an alpaca farm where the small alpaca farmer filed a claim earlier this year, back in January, to argue argue that the local town unconstitutionally took a $310,000 profit from the sale of his farm to pay a $60,000 property tax debt. And so again, yes, it can happen in a rural setting. The principle's the same, and it has happened in a rural setting.
Terrible, those stories, really sad in a lot of those cases, especially that one with the 94-year-old woman in a facility having to deal with the consequences of that and her son. Stressful, to say the least. And I understand that, Minnesota, this is one of the states, but you mentioned that there's 12 other states that also allow the government to still keep these surplus equity proceeds. What are those 12 other states?
Right. Along with Minnesota, it's Alabama, Arizona, Colorado, Illinois, Maine, Massachusetts, Nebraska, New Jersey, New York, South Dakota, and Oregon. And so this is a problem in those 12 states. Now, fortunately, Kansas has a protection in statutory law where that surplus equity cannot be retained by the county or by the state. So once the tax bill is paid and the property is sold off, at least the equity comes back to the landowner. Now, you still lose the property because of the forfeiture sale. You still have forfeited your property, but at least the surplus equity is not retained by some governmental entity.
Sure, absolutely. So with this case in Nebraska that we talked through, where Nebraska kind of saw this case play out and they're like, we don't really think this is right anymore. Is that kind of what we're hoping happens on, a national scale from the Supreme Court case?
Yeah, this home equity or farm equity theft does tend to bear more heavily, and I think this is going to be the way it's argued. The burden of this type of situation bears more heavily on those that can least afford to hire legal assistance or qualify for legal aid simply because you own a property. You're not going to get legal aid because you are a homeowner, because you own farmland. So even though we don't have many cases on this, that may underrepresent the extent of the problem because these people can't afford to be represented. Now, the other thing I would point out is, and this goes to your question as to what the Supreme Court might do here, every state currently bars a lender from keeping the proceeds of a forfeiture sale, but not every state bars the government or a private company that is not a lender from keeping the surplus equity from a forfeiture sale. That should not be. There should be a consistency between those two. So I'm hopeful that the Supreme Court will see the inequity of this. This is not correct. This is kind of an anomaly that's out there, but it's a big issue, and it's happening as states are hungry and hungrier for revenue. This is likely to be happening more often, and probably more than we actually see. But these are some of the prominent cases that are out there, and the Supreme Court agreed to hear this back in January, and we could have a decision this term.
Absolutely. Yeah, that was my next question. With everything else the Supreme Court has weighing on them in this year's kind of lineup of cases that they're taking through, is if this case is actually going to be spoken about this year, whether or not.
Normally, I would say yes, we would see it this term. However, I would say that because the Supreme Court has been strangely slow in dribbling out opinions this term, maybe not. Maybe we won't get it till fall. But I think in any event, we would get a decision before next year's legislative terms across the country with state legislatures. Because if the U.S. Supreme Court reverses the Eighth Circuit on this, these 12 states have to go in and change their statutes.
Absolutely. Yeah, that was going to be my next question too, Roger. You're just thinking just like I am. So what does that mean if, the Supreme Court does rule in with this homeowner, essentially? What does that mean for those 12 other states going from this point forward?
Well, again, what it means is if they don't change their statutes to conform to what many of us think the Supreme Court will do, then we'll see more cases on this. And the state courts will rule consistent with the U.S. Supreme Court that those statutory procedures are unconstitutional. So it's an interesting issue. It's kind of one of these. There are a number of ag-related cases that are presently before the U.S. Supreme Court. And this is one of these that has an ag relation to it, but is kind of under the radar because it's not a high-profile one like Waters of the United States or California Proposition 12. Those are the big ones that are out there. But this is important nevertheless, and we shall see what the U.S. Supreme Court says about it.
Like you said, this year is kind of an interesting one for the Supreme Court in terms of the amount of cases that are really ag-related, like you mentioned.
As I look back every year at the cases, the prominent cases, when I write my top 10 list every year, it's always amazing to me that there are one or two every year that are Supreme Court decisions. And, I mentioned the Proposition 12 and the WOTUS case. There's also a significant Medicaid case that's out there that will bear on asset protection strategies that we often use for farmers and ranchers. So there's three of them out there, and then you add this one in, and that's a full load for U.S. Supreme Court on the things that in ag we are concerned about. No, they all touch on ag in one way or the other.
Absolutely. Yeah. Well, luckily enough, we are lucky to have you as a contributor to Ag Today programming so you can explain all of these important topics to us in an easy to understand way. So, Roger, as always, thank you so much for joining us.
Thank you, Samantha.
Absolutely. Once again, everyone, that was K-State and Washburn University School of Law professor Roger McEowen joining us for this week's Ag Law segment.